Hello, my name's Lucy Keats and I'm a case manager with the Criminal Cases Unit. One of the work streams that I cover is court appointee claims for costs. Hopefully by the end of this webinar, you'll have an understanding of why and when an appointment is made, how to claim back your costs, the regulations and guidance we use in assessing your claim, what work is covered by your appointment, and the process of review if you are dissatisfied with the assessment. The appointment. Following a change to the criminal procedure rules, the Magistrates Court can now appoint the solicitor who's present at the first hearing. This appointment is usually on a provisional basis, which means the court does not have to wait for the defendant to appear, having failed to either get or apply for legal aid or to retain a solicitor on a private paying basis. The court should still invite the defendant to either apply for legal aid or to instruct his own solicitors on a private basis, but in practice, most appointments made at the first hearing where the defendant appears with a duty solicitor will be maintained to trial. An appointment can be made where the defendant has approached a solicitor to represent them. However, the result is that they are unable to pay privately for that representation, and the solicitor will then ask the court to appoint them. An appointment is made under Section 38(4) of the Youth Justice and Criminal Evidence Act 1999. The order of appointment should name the individual within the firm that's appointed, and an application for an appointment can be made by either the prosecution or, previously said, the defence, or the court can make an appointment of their own volition. You must provide a copy of the appointment certificate with your claim for costs. Only work undertaken on or after the date on that appointment certificate can be recovered, and the role of the appointed advocate is limited to undertaking the cross-examination of the named witnesses on behalf of the court. Recovery of your costs. There are two separate funds for the recovery of costs covered by separate regulations and guidance. Central funds, from which claims as court appointees are claimed. These costs and the time claimed are assessed on a basis of reasonableness, and any doubt as to whether those costs are reasonable in amount or have been reasonably incurred are found in favour of the central fund. In legal aid assessment, it's slightly different in that a defendant has a choice of solicitors and counsel, and if a fee earner of a lower grade could have done the work, then that is the rate that is allowed. Unlike in central funds, any doubt as to whether the costs are reasonable in amount or reasonably incurred are resolved in favour of the claimant. As with all central funds determination, the costs of a court appointee are allowed where they are considered to be reasonably sufficient to compensate the applicant for any expense incurred in the proceedings. This is known as the compensatory test. Was the work, and therefore the cost of that work, reasonably incurred? And as I said before, any doubt whether the costs have been reasonably incurred or are reasonable in amount must be resolved in favour of the fund on determination. Regulations and guidance. Your claim will be determined under the Costs in Criminal Cases General Regulations 1986. Regulation 7 sets out the basis for determination. Because the majority of appointments are for work in the Magistrates Court, for which there's no appeal to a cost judge, guidance is limited. Paragraph 3.1 of the Taxing Officer's Notes for Guidance, or TONG, sets out the approach to be taken on all determinations. Additional guidance is provided by the Justices Clerk Society Guidance, which is dated October 2007. This provides guidance on the work which may be considered to fall within the scope of an appointment. In addition, there are two main decisions, CPS versus Abbas. This refers to the JSC guidance and provides some additional clarification in what is within the scope of an appointment. R versus Andrews clarifies the point at which an appointment concludes. Making a claim for costs. Claim forms are submitted to the CCU through a dedicated mailbox. The forms can be downloaded from our website, and you must download a fresh claim form for each claim. The appropriate form to use is based on the date of the appointment. An appointment prior to the 1st of January 2024, the appropriate form is version 5.4, which was issued in February 2024. If your appointment is between the 1st of January 2024 and the 31st of December 2024, you should submit a Form V.CA2024. If your appointment is on or after the 1st of January 2025, you should submit your claim on Form V.CA2025. And again, please download a fresh form for each claim. Hourly rates. Your costs will be assessed using the Senior Court Costs Office Maximum Guideline Hourly Rates, or GHR. These are guideline rates and not mandatory regulations, and were originally intended to assist judges dealing with the summary assessment of costs at the end of a civil hearing. The hourly rate payable is dependent upon the location of the claimant or the court and the grade of fee earner who undertakes the work, not the work carried out. The criteria for enhancement set out within the legal aid regulations are not applicable to the determination of costs as a court appointee. The GHR applied to court appointee claims is considered to provide remuneration reasonably sufficient to compensate, especially when the limited role of the appointee is taken into account. Fee earners. The guideline hourly rate scheme sets out a maximum hourly rate for fee earners based on their status or their grade and their location. The grade of fee earners for central funds determinations are defined as a grade A, senior solicitor or fellow of Silex. The expectation is that they will have at least 8 years qualified experience. A grade B, which is a solicitor or legal executive with over 4 years qualified experience, and also includes cost lawyers who are suitably qualified. Grade C is for other qualified solicitors or legal executives and cost lawyers who are suitably qualified. And Grade D includes trainee solicitors, paralegals or equivalent. Unlike in legal aid assessment, a fee earner cannot be considered as a Grade B because of equivalent experience. They must be a qualified solicitor or legal executive. Recoverable and non-recoverable work. The Section 38(4) appointment does not cover the general preparation of a defendant's case. As an appointee, you are not instructed by, nor do you represent the defendant, and that defendant remains unrepresented throughout the proceedings. An appointee can act for the defendant with the permission of the court, but that can only be on a pro bono basis. Only work undertaken between the date of the appointment and the end of the prosecution case is recoverable. Common points in issue. The grade of fee earner allowed. Whilst the court order will name the advocate appointed, that does not tie the assessor's hands on determination. A case must warrant preparation and/or conduct by a Grade A fee earner for the cost to be considered to be reasonably incurred. It's not considered reasonable for additional costs to be incurred because a firm does not have a Grade B fee earner available. Each claim will be considered on its merits. An assessor will consider several points when considering the appropriate grade to allow, which include but are not limited to the type of the offence, the number of witnesses to be cross-examined, including their age, and any specific needs or difficulties. Whether the case was unusually difficult or complex, or if the case required a legal representative from a specialist field. If the defendant has specific mental health issues or difficulties, that may also be taken into account. If a Grade A fee earner is claimed, you must provide specific representations justifying that claim. Where additional costs have been brought about by a change of fee earner, they are not considered reasonable to be borne by the central fund. Reasonable time will be allowed for the preparation of a case to enable the cross-examination of a named witness. Whilst not binding in respect of court appointee assessments, the Criminal Business Assessment Manual provides support for this position. Attendance at hearings other than trial. The appointment does not cover attendance at most hearings other than when the case is listed for trial. Most hearings will generally be held in the absence of the named witness, and there's no expectation that evidence will be called or cross-examination take place. These hearings will include the first hearing and/or the appointment hearing, an application for bail, a case management hearing, including applications to vacate and pre-trial reviews, special measures applications, applications to adduce the defendant's bad character. This includes where the court has requested the appointee to attend. Where there is an application related to disclosure of the named witness, it may be allowed if the hearing is necessary to obtain vital material for cross-examination and all other methods to obtain that disclosure have been ineffective. Each claim will be considered on a case-specific basis. An appointee is not instructed by the defendant and does not represent them. The defendant remains responsible for preparing and conducting their case throughout. A defendant is expected to inform the appointee of information which may affect the cross-examination. Attendance on defence witness. Whilst it's accepted that an appointee must ensure that they are in a position to properly conduct the cross-examination, this does not necessitate their attendance on defence witnesses. Time will be allowed to consider any statements that are provided by witnesses that may affect the cross-examination. Completion of the PET form is part of the general preparation of the defendant's case and not within the remit of a court appointee. The duty of a firm's solicitors in relation to GDPR is separate and distinct to their Section 38 appointment and is not recoverable. It may be reasonable to allow a period of time following attendance on a defendant to put into note form the information provided by them to assist with cross-examination. I would recommend that you provide a copy of any proof of evidence alongside your claim so that it can be considered on assessment. Whilst it's reasonable for the appointee to consider the defendant's interview as part of the IDPC provided by the prosecution, any question as to the accuracy of that summary is part of the general preparation of the defendant's case and is not within the remit of a court appointee. Whilst it's reasonable for the appointee to consider the defendant's interview as part of the IDPC provided by the prosecution, any question as to its accuracy is part of the general preparation of the defendant's case and is not within the remit of a court appointee. A defence case statement is not mandatory for cases heard in the Magistrates' Court, and any time claimed for drafting will be disallowed. Your claim should not include waiting over the lunch adjournment. Where an appointee attends a defendant in custody or the court by way of a CVP link, other than a very short period, waiting time is not recoverable. It's considered reasonable for a fee earner to undertake other work when in his office waiting for a CVP or video link. Administrative or non-fee earner work is not recoverable. The test is what work is being done and not who is doing it. It includes, but is not limited to, file opening, downloading, uploading documents, printing, scanning, photocopying, transcribing, maintaining an internal diary, and administrative telephone calls. Routine correspondence. Whether an email or letter is routine or can reasonably be regarded as a timed attendance is based on the content of that email or letter. They are only allowed where the content is directly relevant to the cross-examination and will not include client care letters, letters to the defendant, incessant chasing for a response, a long email exchange which could have been one telephone call, and the end of case letter to the defendant. Emails, letters received that are routine in nature are not remunerated on a separate basis. Again, with telephone calls, whether they can be reasonably regarded as routine is based on their content and not length. Only calls directly relevant to cross-examination are recoverable, and where a telephone call is unanswered and a message left, that is not recoverable unless the message in itself constitutes an attendance. Routine items are remunerated at 1/10 of the applicable GHR allowed for preparation. All routine items are allowed at the applicable rate for the grade of fee earner that has been allowed for preparation, unless they are claimed at a lower rate. This takes into account the time that would be needed to instruct a junior to write or send an email or make a specific call. The choice of the appointed advocate is a matter for the court. The court will appoint the solicitor who either attends at the first appearance or who requests to be appointed. A solicitor does not have to accept that appointment. The making of an appointment does not remove or reduce the duty of the assessor to consider the reasonableness of each aspect of the claim, which includes travel time. Where a solicitor who is not local to the court incurs additional unreasonable travel time, these costs fail the statutory test and will be reduced on assessment. Reviews. There is no provision within the regulations for the redetermination of costs from central funds that are incurred in the Magistrates' Court. The CCU will, on request, undertake an informal review of any assessment and take into account any additional supporting documentation or representations that you may wish to provide. The review will be undertaken and you will be notified of the result within 20 days of the receipt of the request. Once that review has been carried out, it follows that the regulations do not include any provision for further appeal, either by way of written reasons or as an appeal to a cost judge. If you would like further information, you can contact the customer service team with the telephone number on the screen, online support web chat, or the CCU direct.